Lawmaking. The doctrine of judicial precedent. Original, binding and persuasive precedents. The doctrine of judicial precedent, or common law, is based on a system of original, binding and persuasive precedents. An original precedent is where a new point of law is established where there was no existing law on the issue. For example, in the case of Donahue v. Stevenson, the House of Lords set an original precedent that a manufacturer owed a duty of care to the ultimate consumer of the product. Mrs. Donahue had suffered a personal injury as a result of drinking ginger beer which contained a decomposing snail. A further example is the legal principle from Shaw v. DPP. The House of Lords set an original precedent creating a new crime of conspiracy to corrupt public morals. The defendant had published a ladies' directory detailing the services offered by prostitutes. There was no existing law criminalizing such activity. A binding precedent is one that must be followed. A binding precedent refers to the point of law set by the court. This is sometimes referred to as the ratio decidendi of the case or simply the legal principle from the case. Once a point of law has been decided by the appeal courts in a particular case, that law must be applied in all future cases containing the same material facts. For example, the point of law established in Donahue v. Stevenson was that a manufacturer owes a duty of care not to injure the consumer. This was the ratio decidendi or legal principle of the case. This point of law had to be applied in Daniel and Daniel v. R. White. The claimants suffered a burn to the throat from drinking lemonade which contained a chemical. The binding precedent from Donahue v. Stevenson had to be followed as the case contained the same material facts of a consumer suffering a personal injury from the product made by the manufacturer. In Grant v. Australian Knitting Mills, the claimant suffered a rash from wearing thermal underwear which contained a chemical. The binding precedent from Donahue v. Stevenson was still binding. The original precedent set in Shaw v. DPP was binding in Nuller v. DPP. In Nuller, the defendant published a gay contact magazine. He was liable for conspiracy to corrupt public morals, the newly created law from Shaw. Persuasive precedents may be highly influential, but unlike binding precedents, they do not have to be followed. Persuasive precedents include decisions from the Privy Council, obiter dicta statements, dissenting judgments, precedents set in other jurisdictions, decisions from the European Court of Human Rights, precedents set in a court lower in the hierarchy. The Privy Council is the final appeal court for the Commonwealth countries. It is housed in the Supreme Court of the UK, and the justices of the Supreme Court sit alongside senior judiciary from the Commonwealth. Decisions from the Privy Council are not binding on the UK court, but as the justices from the Supreme Court are deciding the cases, they can be highly influential and at times are treated as binding. For example, 9 members of the House of Lords heard the case of Attorney General for Jersey v. Holly. Lord Nichols, giving the leading judgment, announced that the decision would be binding in the UK courts. Also, the case of the Wagon Mound, which set the law on remoteness of damage in tortious claims, is widely regarded as binding despite being a Privy Council decision. The obiter dicta is things stated in the course of a judgment which are not necessary for the decision. This contrasts with the ratio decidendi, which is the part of the judgment that is necessary for the decision and becomes the binding precedent. For example, in R v Howe and Bannister, the House of Lords held that the defence of duress was not available to murder. This was the ratio decidendi of the case. The House of Lords went on to consider whether the defence should be available to those who attempt to kill and stated that the defence of duress should not be available for attempted murder. It was not necessary for the House of Lords to consider this aspect as the defendants were not charged with attempted murder. Therefore, the statement made regarding attempted murder is obiter dicta. This obiter dicta from the highest appeal court, although not binding, was highly influential and was applied in the case of R v Gotts. The defendant had been ordered by his father to kill his mother. He stabbed her but she survived. He was charged with attempted murder. The House of Lords applied the obiter dicta from R v Howe and Bannister and denied him the defence. Where a judge in an appeal court disagrees with the majority decision, they must give a speech and state their reasons. This is known as a dissenting judgment. Such judgments may persuade future judges to follow their reasoning rather than that of the majority. For example, Lord Hailsham's dissent in R v Hyam was preferred and followed in R v Maloney regarding the interpretation of Section 8 of the Criminal Justice Act 1967 in relation to oblique intent. In considering whether to add or change the law, judges may look to what approach is taken in other countries and how well it has worked. For example, Lord Gough in Kleinwert-Benson v Lincoln County Council considered the position in America, Canada and Australia and concluded, a blanket exclusion of recovery of money paid under a mistake of law is not regarded as necessary. Parliament retains sovereignty over human rights law. Consequently, decisions from the European Court of Human Rights are not binding. The courts are, however, obliged to take into account the case law arising from the European Court of Human Rights under Section 2(1) of the Human Rights Act 1998. Whilst judges are not required to follow precedents from lower courts, they generally will, in the interest of certainty and consistency in the law. For example, Mr. Justice Denning, as he then was, created an original precedent in the High Court establishing the equitable doctrine of promissory estoppel in high trees. The House of Lords later affirmed the doctrine in Tool Metal Manufacturing versus Tungsten. Where, however, a change is necessary, the courts have the ability to develop the law. For example, in RVR 1993, the House of Lords departed from a line of authorities from the lower courts relating to the marital exception to rape. In summary, an original precedent is where a point of law is decided for the first time. The ratio decidendi of a case forms a binding precedent. This means that it must be followed in all future cases containing the same material facts. There are many forms of persuasive precedent which guide judges in reaching a just decision. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.